Hey, thanks for making it to Veterans Info Tap. I'm glad you made it. The U.S. Supreme Court has taken up a case from two veterans who have alleged that the VA and the appeal process has not administered the benefit of the doubt rule. Now, this rule is essentially if evidence is supplied and it is equal on both sides, the VA and the claims process, including the appeal process, should rule in the veteran's favor. Does this always take place? Well, for those that can hear that, Stan, and Stan thinks no. So these two veterans have taken this to the Supreme Court. Obviously, there's enough legs to get it that far. The Supreme Court has heard the arguments on Wednesday, again, October 16th. I did find another article, and I think that this article might dive in a little bit to kind of what has transpired so far. So bringing you an update on the Supreme Court case. With that, hit the thumbs up, subscribe, share with a friend, all that good stuff. I really appreciate it. The two asks are really look. Hit the thumbs up, really easy, and let the video run. A weird thing happening, not sure why, but I've been seeing some comments that the hitting the thumbs up isn't working. So I don't know if YouTube doesn't like it or what's going on, but strange situation for sure. If you want to support the channel in other ways, consider being a member. I really appreciate it. Thank you so much to all you members. All right, so jumping into it, the headline here is Supreme Court weighs arguments in lawsuit over veterans getting benefit of doubt in claims decisions. All right, the Supreme Court heard arguments Wednesday, and I'm going to insert the 16th of October of 2024, in a case that could determine how the U.S. Court of Appeals for Veterans Claims considers decisions on veterans' requests for disability compensation. So just to set the stage so people understand, because not everybody does, so just to ramp this up, when you file a claim for disability compensation, it's either going to get approved or it's going to come back unfavorable. Unfavorable could mean denied service connection, or it could be a rating. Maybe you thought you should be rated 50%, but instead they gave you a 0 or a 10. Okay, so an unfavorable decision comes back. What do? You now have the choice you could do one of any of these three: higher level review, supplemental, or push it to the Board of Veterans Appeals. You could do all three. You could start off with a higher level review. VA comes back still unfavorable. You could push it to a supplemental claim. VA could still come back as unfavorable for you. Then you could push it to the Board of Veterans Appeals, the BVA. Then at that point, that is overseen by a law judge, a separate entity, and that could come back either remand, deny, or approve. Well, if it comes back unfavorable and they deny your claim, essentially, and back the VA, you still have another course of action. You could take it to the U.S. Court of Appeals for Veterans Claims. Now, if you haven't hired an attorney by this point, I would suggest at least consulting one and having a conversation, because anything, especially beyond BVA, is getting a bit tricky. So that's what happened here, and then they ended up getting, again, an unfavorable decision from the U.S. Court of Appeals for Veterans Claims, and they pushed it to the U.S. Supreme Court. Apparently, it had legs to make it that far, and the opening arguments were heard Wednesday the 16th. So let's jump back into the article here now that we've kind of set the stage on how that whole process works. There's two initial courts, the BVA and then the U.S. Court of Appeals for Veterans Claims. Those are kind of the two veteran courts, if you will, upper and lower. All right, moving back into this. For more than an hour Wednesday, justices peppered attorneys for the plaintiffs and the federal government on whether the Veterans Court is obligated to determine whether the Veterans Board of Appeals, the VA's deciding panel on denied claims, must always consider when there is equal evidence supporting and against a claim. The VA decided in favor of the veteran. All right, so let's move on. The Veterans Court was created in 1988 to review decisions by the board and required the court to ensure that veterans receive the benefit of the doubt in close cases. Sounds like that should happen. I mean, based on that little paragraph. There's no quotations, though. Moving on. Following complaints from veterans groups that the court was Too differential to VA decisions, Congress in 2002 crafted new legislation to instructed the court to take, this is in quotations, take due account of whether the board actually favored veterans in such cases. Such cases referring to if evidence is really close, right? Moving on, in the case of Bufkin versus McDonough, attorney Melanie Bostwick said Congress wrote the law to ensure that veterans received a thorough review. The benefit of the doubt statute has two mandatory requirements. It requires VA to consider all medical and lay evidence. I talk about lay evidence. Lay evidence is awesome. The VA usually screws it up, but the board typically, in my opinion, gets it right. So it requires the VA to consider all medical and lay evidence and information relevant to the issue. And then it requires, if there is an approximate balance of positive and negative evidence on any issue, that the veteran receives the benefit of the doubt, Bostwick argued Wednesday. The federal government, represented by the assistant to the Solicitor General Sopan Joshi, argued that Congress in the 2002 law, only sought to remind the board of its obligation to give veterans the benefit of the doubt, and the court is limited only to review the board's decision for error. If it's a new review, that means that in every case, the appellate court is going to review the entire record, assign weight, balance things, Joshi said. Appellate courts are not well suited to do this. Then who should do it? And why would it get to this level with no sort of recourse, right? So if you're not going to get it right here, and you're not going to get it right here, and you're not going to get it right here, and you're not going to get it right here, when are you going to get it right? And the here's that I'm pointing at are higher level, supplemental, board, appellate. So that would be my concern. Veterans, Joshua Bufkin, who served in the Air Force from 05 to 06, and Norman Thornton, a former Army soldier who served from 88 to 91, filed suit against the VA, saying the board and later the court did not follow that law. Both plaintiffs applied for benefits but were denied repeatedly by adjudicators on appeal. Bufkin served for 6 months before receiving a hardship discharge because of family issues. He later filed a claim for post-traumatic stress disorder, saying he was traumatized by his wife's threats to kill herself if he didn't leave the military, and pressure by the Air Force that he leave the service. VA medical assessments of Bufkin's case conflicted, with physicians disagreeing on whether he had PTSD, and if so, was it service-connected. In Thornton's case, the VA awarded the Desert Storm veteran a 50% disability rating and said his symptoms did not qualify him for a higher rating, although one assessment determined that he had at least one measure that may have qualified him for a 70% rating. While the justices were considering the legal questions of the case and whether the VA was following Congress's wishes, several asked questions about the effects a different ruling would have on the plaintiffs. There's a quotation here. I just don't understand exactly what Mr. Thornton stands to gain because of his unemployability. Wasn't he given complete disability? So what further relief could he get if he wins before us? Asked Justice Amy Coney Barrett. Bostwick said that under his circumstances, Thornton is subject to continued review of the unemployability benefit, and that a different ruling would remove that uncertainty and maybe entitle him to special monthly compensation above the 100%. Joshi noted that Bufkin presented medical opinions saying that he suffered from PTSD and others that say he didn't. And later, examinations found that his PTSD diagnosis did not measure up against the standards set in the diagnostic manual. What constitutes an approximate balance, how far away the scale should be? The court is expected to release its decision next spring. Attorneys agreed that something must be done to provide guidance on the Veterans Court, which handles 1,100 cases in the last year. I think it's going to be a big deal, Joshi said. I think the vast majority of cases that get appealed to the Veterans Court are rising essentially factual cases, or essentially factual challenges to findings that there are no present disability or no in-service connection or no causation. Our view of the statute is that that this is something the Veterans Court has to do in every case, Botswick said, of the benefit of the doubt consideration. So, look, here's my thing. I think, yes, the benefit of the doubt aspect should absolutely be looked at. I think that that's probably one of the biggest issues. And the reason why is because many veterans lack just an overwhelming amount of evidence, right? We lack that because we were told don't go to medical, don't go to sick call, don't go document any of that, rub some dirt on it, drink some water, change your socks, take some Motrin. And because of that, we have no evidence, or very little. And of that very little evidence, we're trying to supply it just to get to that equal amount. And then we rely on the benefit of the doubt at that point. So, as one example, anyway. So with that, that's the update so far. We'll keep an eye on it and keep you informed. Thanks for watching. I appreciate you. Have a great one. And remember, if we don't take care of each other, something went wrong.